Hi, everyone. Today we're going to be discussing the top 5 things to consider when filing a marriage green card in the United States. So stay tuned to the end of this video so that you can learn all about the marriage green card process in the United States, which in turn will help you and your spouse to better prepare for this detailed journey ahead of you. And it will also help you to understand what it's going to take from you and your spouse to achieve your goal of obtaining a green card through marriage in the United States. So if this is something you're interested in, stay tuned. Hi, my name is Attorney Sonia Peterkin. I am an immigration attorney, and this is a great topic to discuss for those who are interested in obtaining a green card through marriage here in the United States. It is such a great topic that I've written on it, and you can find this article on my website, www.sapeterkinlaw.com, as well as a lot of other articles pertaining to immigration law. So today I'm going to be using that article to break down the process for you in an easy to digest way. So let's dive right in. The first thing you want to consider when applying for a marriage green card case in the United States is that you have to prove that the marriage is in good faith. So what does it mean to have a good faith marriage? It means that you intend to build a life together. Well, how can you prove that you intend to build a life together? You're going to do that through lots of documentation and through credible testimony that you're going to provide at a interview that is going to be scheduled towards the end of your case. So you have to provide sufficient documentation of that. And keep in mind that officers have seen instances of marriage fraud thousands of times. And so it is your obligation to persuade an officer that your marriage is the real deal. And you're not going to be able to do that just through a marriage certificate. You have to do that through other documentation, such as joint bank accounts or large purchases that you make together, which can be proven through receipts, joint insurance policies, and other estate planning type of documents like wills and trusts. But you're going to do this through documentation and through credible testimony that you're going to provide at the time of the interview. And it's very important that you do this because if you're unable to prove a bona fide marriage, your case will be denied. And in addition to that, you can be placed in deportation proceedings. And if you've been found to have committed marriage fraud, there are serious consequences for that. It is a felony to commit marriage fraud. And so you can face, both you and the U.S. citizen can face criminal charges and fines. And there will be devastating future consequences with other immigration cases that you may want to file. So it is absolutely imperative that you are able to document your marriage well and that you can prove that your marriage was entered in good faith. The other thing that you want to consider when applying for a marriage green card is that there are plenty of reasons for your case to be denied. So it doesn't all hinge on whether you can prove that your marriage is a bona fide marriage. There are so many other reasons for a denial. Those reasons include a person's health. So if the applicant has certain communicable diseases, they probably won't qualify for the green card. Every applicant who's applying for a green card through family sponsorship must have a medical examination done, and they must provide this medical examination to the officers to prove that they don't have any illnesses or diseases that would make them inadmissible into the United States. Inadmissible is a term used to describe a person who doesn't qualify for admission into the United States. Another reason that a person can be denied a green card through marriage is if they have criminal history. And immigration has a very unique way of categorizing different criminal offenses. So what may seem like just a minor misdemeanor could have very serious consequences and prevent you from being able to get a green card, or may require you to apply for a waiver. A waiver is something that you would file in order to ask the government to overlook or forgive an offense that you've committed in the past. So it is completely discretionary, complicated. You would definitely need an attorney for that. And whether you can apply for a waiver is going to depend on the actual offense. Okay? The other thing that could cause a denial is your immigration history. So if your immigration history involves things like unlawful entries, a prior deportation order, and things of that nature, that could prevent you from being able to apply for a green card. Or it might require a waiver, or it just makes the process a lot more complicated. So if you have any of those types of situations, you definitely want to consult with an attorney before you file any paperwork with immigration. Once you file an application for an immigration benefit, it now puts you at the forefront of the government, and they will perform a background check, and these things will come up. Okay? The third thing that you want to look into or consider when filing a marriage green card is that you can't leave the country as soon as you file your application to adjust your status based on marriage. Adjustment of status is the term used to describe the process of applying for a green card while living in the United States. So if you're going to be applying for adjustment of status, you're not allowed to just leave the country immediately after filing. If you do, you can abandon your application, which will result in a lot of wasted time and money. So you definitely don't want to do that. Instead, what you want to do is apply for advance parole, which is just permission to leave the country and re-enter. So you would apply for it at the time that you submit your application for adjustment of status, and you'll wait until you get an approval and receive your advance parole document. Once you do that, you can leave the country and re-enter without worrying about abandoning your application and wasting a lot of money and time. Number 4, the U.S. citizen or permanent resident petitioning spouse must commit to financially supporting their foreign national spouse, even after divorce. Yes, I said even after divorce. So, a U.S. citizen or permanent resident who is sponsoring a foreign national spouse must complete a Form I-864 affidavit to support. And this form is a legally binding contract between the U.S. citizen or permanent resident and the United States government. And it's basically a promise to both the government and the sponsored immigrant that they're going to financially support this foreign national spouse, and that they will do so until one of these things occur. Either the sponsored immigrant becomes a U.S. citizen, the sponsored immigrant is no longer a permanent resident, the sponsored immigrant works at least 40 quarters under the Social Security Act, or the sponsored immigrant dies. So notice that the marriage dissolving is not one of the things that ends this obligation. And also keep in mind that when you complete this form, if the foreign national spouse receives government assistance, that government agency can sue the petitioning U.S. citizen or permanent resident for reimbursement for the benefits that were received by the sponsored immigrant. And these obligations don't just pertain to the petitioning spouse. These obligations pertain to the household member or joint sponsor that signs the Form I-864 or I-864A. So it's very important to know what you're signing and what legal obligations you have based on signing these forms. This form is necessary for all family-based immigration cases. The last thing you want to consider when filing a marriage green card case is that if your marriage is fairly new you're going to receive a 2-year green card, also known as a conditional green card. So, if your marriage is less than 2 years old at the time that you've been approved for your green card, you're not going to receive your normal 10-year green card. You're going to receive a 2-year green card, which will require you to apply to remove the conditions from that green card. And you're going to do so by filing a Form I-751, Petition to Remove Conditional Residence. And this is going to allow you to receive your 10-year green card if you can successfully prove that your marriage is bona fide. Again, so yes, the government expects you to prove that your marriage is bona fide, not just once, but twice if your marriage is fairly new. They do this in order to prevent people from getting married and then getting divorced right after they get their green card. They want to be able to spot marriage fraud, and they believe that this is the way that they can do that. So if your marriage is fairly new, there is more documentation that you have to provide in another responsibility to show once again that your marriage is bona fide. Another thing that you should know about the I-751 is that these applications are pending for 18 months or longer. So while you're waiting for this application to process, your green card will expire, but you're going to receive a receipt notice, which also serves as an extension letter, and it's going to extend your permanent residency. So you will have proof of your residency status while waiting on your I-751 application to be adjudicated. And in some circumstances, you may qualify for naturalization while your application is pending. Not all I-751 applicants have to attend an interview. So if you properly document your case, it heightens the possibility that you will not have to attend an interview. Most people prefer not to have to attend an interview. Now, if you successfully prove that your marriage is bona fide again, then your conditions will be lifted and you will receive a 10-year green card. The I-751 application requires that both you and your spouse file jointly to remove the conditions from your green card. However, in some circumstances, that is not possible. It could be because your marriage has ended, because your spouse has died, or because you are the victim of domestic violence. And in those situations, we can apply for a waiver that would allow you to apply to remove the conditions from your green card independently. It's very important that your application is approved because only once it's approved will you receive your 10-year green card. If it is denied, you will be placed in deportation proceedings. If I could be of any assistance to you with the filing of your marriage green card case, you can contact me with the information below.